Hello, my name is Christina Angelopoulos and I am an Associate Professor in Intellectual Property Law at the University of Cambridge. In recent years, my research has focused on the effect of copyright law on access to and reuse of scientific publications. The central issue is as follows. Most scientific publishers require an assignment of copyright or an exclusive license in the scientific articles that they publish. As a result, although researchers are the ones who produce scientific publications, as well as generally the ones who undertake their peer review, copyright in such publications is passed entirely into the hands of parties who arguably make a lesser contribution to scientific progress. As a lot of funding, moreover, for scientific research is public, whether it comes from universities employing researchers or from third-party funders, the ultimate result is a transfer of public investment into research to private publishers. Given that research institutions are of course obliged to purchase access to proprietary scientific journals and databases from publishers in order to enable future research by their employee researchers, this situation has attracted heavy criticism. This criticism has intensified in light of what is known as the serials crisis, that is, the drastic increase in subscription prices to scientific journals in recent decades. Against this background, a number of experimental solutions have emerged across the world at both the legislative and the non-legislative levels. At the non-legislative level, rights retention strategies are being used by researchers. This refers to requests by researchers that publishers allow them to retain republication rights after the publication of their scientific articles in journals. University employers or research funders may require such rights retention by researchers, and where such parties require that republication is made available online in open access, we have what are known as open access mandates. That said, power differentials between researchers and publishers and the heavy incentives that push researchers to publish in reputable journals make rights retention strategies often difficult for researchers to pursue in practice. With this in mind, a number of EU member states have in recent years considered ways in which they can offer legislative support to researchers via copyright law. An important mechanism that has arisen in this regard is the so-called secondary publication right, or SPR. The secondary publication right refers to a new right for authors of publicly funded scientific publications to make the text of those publications freely available to the public without the permission of the publisher after its publication in a scientific journal. To date, 6 EU member states have adopted a secondary publication right. In chronological order, these are Germany, the Netherlands, Austria, France, Belgium, and most recently Bulgaria. The right is also under discussion in Italy, while Spain has introduced a secondary publication obligation. Although important differences exist between the different countries, the secondary publication right is generally limited to a non-commercial online dissemination of research that is at least partly publicly funded. With the exception of the Bulgarian provision, the right is limited to articles in scientific journals. Also, with the exception of the Bulgarian provision, the secondary publication right imposes an embargo period before the expiry of which republication by the author-researcher is not possible. This embargo period varies between countries from 6 months to 1 year after the first publication in the scientific journal. Germany, Belgium, Austria and France explicitly limit their secondary publication rights to the author-accepted manuscript, although the Dutch and Bulgarian secondary publication rights leave the issue open, potentially therefore enabling the secondary publication of the version of record. Except in France, the first publication must be cited by the author-researcher when making the work available via the secondary publication right. In all cases, the secondary publication right is inalienable and unwaivable, so that any deviating agreements to the detriment of the author-researcher are without effect. This condition is essential to make the secondary publication right useful, as otherwise it would lose its power vis-à-vis publishers and could easily be ceded or negotiated away in the publication agreement. As a tool for the encouragement of open access to scientific publications, the secondary publication right is undeniably attractive. A key advantage is the simplicity it brings, freeing authors from the burden of navigating numerous differing publisher policies on self-archiving and the stress of negotiating suitable solutions with publishers. It has therefore been suggested that a harmonised secondary publication right be adopted at the EU level. Indeed, LIBA, the Association of European Research Libraries, has proposed precisely such a draft law for an EU-wide secondary publication right. The suggestion has been taken up by the European Commission, which has recently commissioned studies for the purpose of examining the possibility of adopting the secondary publication right at the EU level. An EU-wide secondary publication right would fit well with the European Commission's ambition to enable all scientific publications resulting from publicly funded research being made freely available. I hope this brief description has been helpful.